Everyone, we are the students of Business and Corporation Law subject. Our subject code is HI 6027 and we are the students of M2 group. Today we are going to present a very unique case of ASIC versus Citigroup 2007-963 Federal Court of Australia. And my name is Simranjit Kaur and my student ID is SCG 3004 and here is my friend
Rajni Srivatsa, TIA 3019.
Krishna Sapkota, KAC 3210.
Sabina Kumari Thaman, KAC 3174. We are the counsel for the plaintiff. Respondent was performing a business through the various business division. These divisions were equity trading and business investment banking. Investment banking, which has been a private business trading, whereas equity trading is a public side business. These two were separated by in order to separate and maintain the confidentiality of the information related to the finance. These were separated by the Chinese wall. The adequacy of the Chinese wall arrangement, also known as the information barrier, can determine the liability for the insider trading. Now I would like to invite my friend Krishna Sapkota for proceeding the facts.
I'm going to talking about the facts of the cases. The Citigroup had two bodies. One is the equity and trading and another one is the investment banking. The equity and trading, which is the public body of the Citigroup, who purchased the share of Patrick Corporation Limited, which happened when the investment banking IB division was advisory body of one of the client's toll. The toll holding on the proposed takeover the bid for Patrick. The share was purchased on the previous day before the toll announced its bid for the Patrick. The another fact is that when IB means investment banking came to know that ET had purchased share from Patrick, then ET was told to stop for buying any more share from Patrick. ET did not purchase any more share, but half of an hour before closing the trading, ET sold around 200,000 shares on profit. Toll subsequently announced its takeover bid for the Patrick for the following days. Now I would like to call my friends.
May I, with the permission of your honor, would like to present the issues of the case on behalf of ASIC. ASIC alleged that the ET was in possession of insider information when it purchased the shares. As a result of what was said to ET after IB discovered the potential conflict of interest, ET had made a supposition that Citigroup was acting for toll in the proposed takeover of Patrick. ASIC alleged that this supposition constituted information within the meaning that the term in Section 1042A of the Corporation Act 2001. Accordingly, the sale of 200,000 shares was alleged to have constituted insider trading by Citigroup. This has been the first insider trading claim. The second one is the fiduciary position claim. That is, the Citigroup occupied a fiduciary position as an advisor to toll in proposed bid for Patrick. By purchasing the shares of Patrick, Citigroup breached its fiduciary duty, thus breaching its obligations under Section 912, Clause A, Subclause 1 of the Corporations Act 2001. Further, Citigroup breached the provisions of the Section 1043H of the Corporation Act 2001, as well as the Section 112DA of the ASIC Act, which prohibited misleading and deceptive conduct on the part of Citigroup. This has been the fiduciary claim. The third claim had been that ASIC challenged the Chinese wall Citigroup had in place. ASIC alleged that because senior IB personnel knew that there was a substantial likelihood that toll would launch its takeover bid, that knowledge was attributable to Citigroup as a whole. Accordingly, ASIC alleged that Citigroup engaged in insider trading because Citigroup's ET division bought the shares. This has been the second insider trading claim. Besides to this, ASIC also alleged that the adequacy of Chinese wall is not sufficient. To do the further proceedings of the judgments, I would like to call my friend Simranjit Kaur. Thank you.
Now I would like to present the final judgment of the court. The court rejected all the claims made by the ASIC, and the very first claim that was rejected by the court is that Citigroup didn't engage in any insider trading. In order to make Citigroup liable for the insider trader, ASIC needed to show that the trader was the officer of the Citigroup. But the court had found that ASIC had not proven that the trader had made any necessary deduction that Patrick would be subject of a taken over bid. Finally, the trader was not the officer of the Citigroup. That means even if he had made any deduction, that was not attributed to the Citigroup. The second claim that was rejected by the court is that there is no any fiduciary relationship between the Citigroup and toll. The court observed that while the relationship between the investment bank and toll in a takeover was not one of defined classes of fiduciary relationship, because the contract between Citigroup and toll in the form of mandate letter provide that Citigroup was to act as an independent contractor and not in any other capacity, including as a fiduciary. Importantly, ASIC considered that no fiduciary had arisen between Citigroup and toll prior to the execution of the mandate letter, but in fact, parties having been in the relationship since January 2005. And the final judgment that was made by the court is that Citigroup had adequate arrangement in place to manage conflicts. The court examined that the Citigroup's arrangement for the management of conflict of interest were adequate, as they have some key aspects of their Chinese wall, such as they have physical separation of departments, they have educational programs and monitoring by compliance officers. Thank you.